So ladies and gentlemen, before I begin with the actual openings in this case, I just want to make a few comments with regard to opening statements, and those are these. In any case, but particularly in a labor law case, before you ever open to the jury, it is absolutely incumbent upon you to take a look at the pattern jury instruction, specifically 2:217, which is at page 423 of the 2012 Gray PJI book. And it's incumbent upon you because obviously that is going to be the exact thing that the jury hears at the very end of the case from the judge. And so I think it's incredibly important for you, no matter what side you're on, plaintiff side, defendant side, to use those classical portions of the pattern jury instruction. So for example, in a labor law case, you want to talk about proper protection. You want to make sure that you use the terms sole proximate cause. You want to make sure that in your opening statement, you talk about the proper placement of a ladder, whether or not the ladder was properly secured, and all of the buzzwords that the jury is going to be hearing from the judge. It gives you a tremendous amount of credibility with the jury. They'll later reflect and say, oh, I heard the plaintiff's attorney use those words. Now the judge is telling us those words. It must mean something. And so I think that's the first rule when preparing for opening statements in any case, is to familiarize yourself with the exact law that the jury is going to be getting at the end. Another very important thing that I think you have to remember when you're doing an opening statement, and that is this. It's really super important that when you're doing your opening statement, try to avoid using any cliches. I'm sure everyone who is here has heard a lawyer sometime in their life get up and say, ladies and gentlemen, an opening statement is not evidence. Why would you ever want to do that? Why would you ever want to tell the jury that what you're about to tell them is not evidence? They'll hear that from the judge. Maybe their adversary is going to say it, but why use a cliche like that, which just undermines your credibility in terms of what you want the jury to be thinking? Of course you want them to be thinking it's evidence right from the beginning. And so avoid cliches, particularly that one. Other cliches that I hear being used all the time is an opening statement is like the table of contents of a book. Avoid those sorts of cliches. They're boring for a jury, but more importantly, they really get you nowhere. Another rule for opening statements. Make sure if you are going to be delivering an opening to a jury, that you deal in your opening with any of the difficulties that you perceive in your case. I call it the ostrich rule. Make sure you're not an ostrich with your head in the sand. And so, for example, in this particular case, I know you've all read the fact pattern. If you're the plaintiff, you're dealing with the fact that there is this allegation of intoxication, there's this allegation of a beer, and you need to deal with that. There's an allegation that there's a cooler of beers, and that in this particular case, the plaintiff, Kroger, offered a beer to the security guard. Deal with it, and deal with it up front. There's also, in this particular case, if you're the plaintiff, there's the problem that your client stopped going to physical therapy. You don't want that to come out for the first time when the defendant's lawyer gets up there in his or her opening statement. So it's really important to be able to deal with those important aspects of the case where you might have a little bit of a problem. Figure out how you're going to deal with that problem from the beginning of the case and deal with it in your opening statement. So with that said, let me start in this case of Kroger versus Delta, Kroger versus Faber and Vernon, and I'm going to start out and I'll first do the plaintiff's opening statement. May it please the court, Your Honor, counsel, ladies and gentlemen of the jury. This case is about failures. This case is about the defendant's failure to provide my client, Larry Kroger, with a safe place to work. This is a case about the defendant's failure, which led to a horrible and catastrophic accident. Ladies and gentlemen, I told you in jury selection that we have brought this case under very special laws written by our legislature and signed by our governor, which have been effective in the state of New York to protect those workers who you see dangling off the sides of buildings, who climb up those scaffolds, who work at heights that none of us would ever dream about going to. And those specific laws, known as the labor law in the state of New York, were completely ignored in this case by these defendants, the owner and the general contractor. There were multiple failures by the owner and by the general contractor in this case, each of which was a substantial factor in causing very significant injuries, permanent, lifelong injuries to my client, Larry Kroger. The evidence in this case will show you that these defendants failed to inspect the work while the work was going on. That these defendants, in contravention to the law in the state of New York, failed to make sure that at this job site, Larry Kroger had the benefit of a proper and appropriate safety device. They failed in their obligation to make sure that at this job site, the proper and appropriate safety device was properly placed. They failed to make sure that at this job site, an extension ladder or a scaffold, two items well known in the construction industry, they failed to make sure that either one of those was used, and they allowed an A-frame ladder, which I'm going to tell you a little bit more about in a minute, to be used in place and instead of those. And the evidence will show, ladies and gentlemen, that that was an inadequate, an improper safety device. Now, let me take you back to September 10th of 2010. Let me take you back to that day so that you can more specifically understand what we're talking about. This accident happened up in the city of White Plains. And the accident happened when my client, Larry Kroger, was working on a commercial building. At the time of the accident, Larry was 38 years old. And let me take a moment now to introduce you to Larry. He's the person sitting here with his wife, Mandy, in the first row. And at the time of this accident, which occurred in the evening, at the time of this accident, Larry was a self-employed painter. He had a little company. He was the only employee of that little company. That little company was called Delta. And Larry's job was as a painter. And as you'll hear later, when he has a chance to tell you about himself and about what happened in this accident, Larry loved his job. Larry considered himself good at his job. Larry got a lot of jobs, many contractors, hired Larry because he knew what he was doing and he was good at it. The evidence in this case will show, ladies and gentlemen, that the owner, Faber Properties, and the general contractor, Vernon, that Vernon, on behalf of the owner, hired Larry. In fact, Larry had worked together with Robert Hoover, who's the general contractor's foreman, on many other job sites. And on this particular day, because before you paint a building like this, and you'll see pictures of this building during the course of this case, and in fact, you'll see photographs from the very day of the accident taken by a cell phone by one of the people who was in the vicinity. And it's just common sense. In order to do painting, the first thing you have to do with a building like this is you have to power wash it. And so Larry was asked to come to the building, to first power wash it, and then to do the outdoor, the exterior painting of this particular building. And he had a conversation, you'll hear all about it, with Mr. Hoover, and he told Mr. Hoover that because the owner doesn't really want anybody up power washing while the building's in a lot of use during the day so people coming in and out don't get wet, he agreed that he would come and he would do it at 5:30. He would start the power washing at 5:30 in the evening. Now, Hoover, knowing that the power washing was going to begin at 5:30 in the evening, Hoover, being the foreman of the general contractor, who knows that they are responsible for the safety at the site, what does Hoover do, knowing that the power washing would start at 5:30? I'll tell you what Hoover does. He leaves. Goes home. You're on your own, Larry. Hoover goes home without ever inspecting the equipment that was being used, without ever looking at where that ladder was placed. And Hoover goes home without ever having a discussion with Larry about any of the safety aspects of this job. So what happens? 5:30 comes, Larry, in accordance with his responsibilities, comes to the job site. Sets up his ladder. This is a commercial building that has, outside of it, in the area where Larry was doing his power washing, a concrete sidewalk, which is very narrow, and behind it, there is grass. So, Larry has with him an A-frame ladder. And most of you know what an A-frame ladder is. Many of you probably have one in your garage. An A-frame ladder is that scissor-type ladder that you open up, and it's got two sides to it and a platform at the top. Now, when Larry opens up the A-frame ladder, he puts the ladder up against the building so he can do his power washing, but the back 2 feet of the ladder have nowhere else to go but on the grass. Nowhere else to put the back 2 feet but on the grass, not because of anything Larry did, but that's the type of a building that this is. And so he begins his work, doing it as best as he can, working under those circumstances. Hoover is nowhere around. And while Larry is up about 8 rungs on the ladder, about an hour or so into the job, the evidence will show that the ladder shifts. Larry tries to counterbalance the shifting ladder, but falls. Falls from the 8th rung of the ladder. The ladder shifts because the back legs are in the mud. The grass became mud. The ladder sunk, part of it did, and down goes Larry. And the evidence in this case, ladies and gentlemen, will show that had the owner and general contractor provided the proper safety equipment, had they provided an extension ladder, and you all know what those are. Those are the ladders that have 2 feet that can be placed up against a building, up against a structure, and extended. There would have been no need to have 2 feet in the grass. There would have been no shift of the ladder, and the job would have been complete without having ruined one man's life. The evidence will show, and you'll listen very carefully at the end of this case to the charge, to the law that the judge gives you in this case about the owner's absolute obligation, hand in hand with the general contractor, to make certain, no choice, but to make certain that the proper and appropriate equipment is used at the job site. You will also hear evidence in this case, ladies and gentlemen, that if it wasn't an extension ladder to be provided by the owner or the general contractor, they could have also provided him with a scaffold. A more rigid structure, a wider structure. And this general contractor owns scaffolds. They own tons of these scaffolds. And the evidence will show that they could have easily brought a scaffold like that to this job site. Had Hoover not been home watching TV or doing whatever he was doing, he could have also put a piece of plywood over the grass. And had there been a piece of plywood on top of the grass, that too would have provided a firm area for the ladder to sit. But their failure to supply the appropriate device and make sure that that device was properly placed was the substantial factor that caused this accident. Now, ladies and gentlemen, you are going to hear from a number of witnesses in this case. And you're going to hear from today, one of the key, most critical witnesses in this case. Today, you are going to hear from Mr. Hoover. Mr. Hoover is going to be called by us, by the plaintiff. He's going to be called as an adverse witness by my partner, Ben Rubinowitz. And Mr. Rubinowitz is going to establish in that cross-examination that Larry Hoover knew the layout of this building. He knew about the amount of concrete slab and that the grass was indeed right behind it. Larry Hoover will concede that he knew that there would be power washing going on here, and that, of course, the power washing would make the grass wet, and that, of course, with enough water, not only would the grass get wet, but there would be a muddy condition. And Larry Hoover will admit to you under cross-examination that if he himself were there, he would never have allowed an A-frame ladder to be used, because he knew that 2 feet would have to go in the mud. Larry Hoover, ladies and gentlemen, will agree that the A-frame ladder was inappropriate and that an extension ladder or a scaffold were the appropriate and proper safety devices for this job site. He will also tell you that had there been a piece of plywood put down, that piece of plywood could have prevented this entire accident. And that, yes, of course, his contracting company owns pieces of plywood and can easily get the kind of piece of plywood for just a couple of bucks that could have prevented this entire accident. Ladies and gentlemen, the labor law in the state of New York is clear. In this particular case, you will hear all the evidence. And at the end of the case, I will have another chance to stand up to you and talk to you about the entire case, and specifically about the liability part of the case. And at that time, it will be clear that the defendants failed in their obligations under the label law to provide a proper safety device, to provide a safety device that was properly placed, and to provide a safety device that was properly secured. Now, in addition to hearing testimony with regard to the liability, you will also hear testimony in this case with regard to the damages. And you will hear this testimony in great detail from my client himself, and in addition to him, from medical experts. And you'll hear, ladies and gentlemen, that after this fall, this otherwise very active 38-year-old man with a wife and 2 children was laying on the ground screaming in pain. He was taken by ambulance to the White Plains emergency room, immediately given morphine for the extreme pain that he was in. And you'll hear his own description of how his feet, how his legs looked, that he couldn't even bear to look at them, and that the nurses said, lay down, don't look, don't look. Why was that? Because he sustained serious fractures to both of his ankles as a result of this fall. With regard to the right ankle, he sustained what is called a tri-malleolar fracture. And the evidence will show you that that is essentially a 3-part fracture of the ankle joint. And in this particular case, with regard to his right leg, it was comminuted, meaning it was splintered, it was in multiple pieces, and it shattered. He had for his right leg what is known in medical parlance, and you'll hear the acronym during the course of the trial, an ORIF, open reduction internal fixation. We will show you the x-rays of how his ankle looked before the open reduction with internal fixation, and we will then show you the x-rays in this case of how his ankle looks with the 12 screws and the 2 plates in his right leg. He also sustained a very significant fracture of his left leg. That fracture was not as significant because that was a bimalleolar fracture involving 2 portions of his ankle. But that fracture, too, in and of itself, is a serious and significant and debilitating injury. And that fracture, too, had to be treated with another ORIF, an open reduction with internal fixation. And you're going to hear that the left ankle fracture had both an impactional and a rotational component to it, that it took a while for them to be able to align the bones before they could use the screws and before they could use the plates. And ladies and gentlemen, you're going to hear from the physician who actually did the surgery, and what you're also going to hear is about how important these surfaces within the ankle bone, within the ankle joint itself, are to one another. You're going to hear that these are called articular surfaces, and that the bones, when they lean up and rest against others, the way we were made, those surfaces are smooth. But when they are fractured in the way they were fractured in this case, they are no longer smooth. And when they are no longer smooth, by definition, even the defendant's doctor will admit this, by definition, there is permanent arthritis. And you will hear that what this particular injury has meant in terms of its pain and suffering to my client. But in addition to that, ladies and gentlemen, you're also going to hear about what it's meant to his family, because as a result of this accident and these devastating fractures, he can no longer work in his given field as a painter. He can't carry, he can't certainly. Nobody would ever expect that he would climb ladders again. And you will hear from an economist as to the amounts of money. He's making around $75,000 a year. He's only 38 years old. And you'll hear all about what that meant to him and his family and what that loss means going forward into the future. And by the way, ladies and gentlemen, I do want to mention to you that there came a time where Larry did stop going to physical therapy because his household was so hectic. And his wife got a job, and so she had to work, and he was home. And so yes, he missed some physical therapy appointments, but he'll tell you in his testimony that at that point in time, he had done as much as he could at the physical therapist's office, and that he was, in fact, at home doing as many exercises as he could to make himself as best as he could. Now, I want to mention something else to you. You may hear testimony in this case from a guy by the name of Diller. The defendants have made an issue in our discovery process, and you know what that process is all about from the judge's preliminary instructions, about this guy Diller, the security guard in the building. And this guy supposedly had a conversation with the plaintiff in which he claims that the plaintiff offered him a beer. And he also claims that there was a cooler of beers and that the plaintiff himself, my client, was somehow intoxicated. Well, ladies and gentlemen, the evidence in this case will show you that if they do attempt to bring Diller to this courtroom in order to deflect attention from their violations, their clear violations of the labor law, you will hear the cross-examination, probably a rather harsh cross-examination of Mr. Diller, because there is not one scintilla of evidence in this case, not one scintilla of evidence other than Diller about any level of intoxication. If Kroger, my client, was in any way intoxicated, don't you think the police might have put that in their police report? And maybe the cops, maybe they were too busy doing other things, so maybe they forgot. Don't you think the ambulance people would put it in the ambulance record? And maybe they were too busy too, will say the defense. Well, don't you think the hospital would have one entry, one record? The evidence will show that there is none of that. It is not in the police report. It is not in the ambulance report. And it is certainly not in the hospital record. Ladies and gentlemen, if the defense makes that argument, please keep your eye on the ball. It is just another desperate attempt by them to avoid liability in this case. At the end of this case, I'll have another opportunity to speak to you. And at that time, I will get up here and I will ask you for a full verdict for 100% justice on behalf of my client, who was horribly injured as a result of the violations of the labor law by both of these defendants. Thank you so much for your time. Thank you for listening to me, and I'm sure you'll pay the same close and careful attention to my adversary. All right, now for the defendant. May it please the court, ladies and gentlemen of the jury, my very, very worthy adversary, Your Honor, there is one cause for this accident. There is one sole proximate cause for this accident. There is one person at fault for this entire unfortunate accident. And that person, ladies and gentlemen, is Larry Kroger himself. Larry Kroger has no one to blame but himself. It is our position, and the evidence will be abundantly clear in this case, that the sole reason this accident took place was because of the actions of the plaintiff, Larry Kroger, himself. Had he taken out the time to do his job in a responsible manner, we would not be here today. And if Larry Kroger would take responsibility for his own actions, we would not be here today. But instead, ladies and gentlemen, he wants to blame someone else. Someone else for his own accident, one in which he was the sole proximate cause. Now, I told you in jury selection that I represent both the owner of the property, Faber Partners, and the general contractor, Vernon, two local New York companies that employ lots of folks in the county of Westchester and other places. And I'd like to introduce to you today the two representatives that are sitting here from both of those companies. And the first is the general contractor, and that's Mr. Hoover, who is here, and Mr. Faber here on behalf of Faber Properties. Now, I want to tell you that with regard to Faber, the owner of this property, the owner was not there at the time of the accident. The owner owned several other buildings in the county of Westchester and other places, and they hired the general contractor to do the work, to do the work that was going on inside, and of course to supervise the job site on the outside, all the work that was being done on the outside. Now, in this particular case, ladies and gentlemen, the evidence is going to show that there was a relationship between the general contractor and the subcontractor, between my client and the plaintiff, that Hoover and Kroger had worked together on a number of other projects in the past. And there was absolutely no reason that Mr. Hoover needed to be there to supervise a man who had more than 15 years of experience as a painter. There was absolutely no reason for him to be there. They had discussed this job in advance. In fact, the plaintiff had been to the site in advance. And so it's clear to you, the plaintiff in this case, Mr. Kroger, he is an independent contractor. He's got this company of his own. He runs around from job to job and place to place. And he himself supervises the means and the methods of his own work. No one tells him how to do his work. And can you imagine telling a guy who's been a painter for 15 years how to do his work? No one in this case told him what ladder to use or where to place his ladder. Those were decisions that the evidence will show were his and entirely his. And there was absolutely nothing about his past experience that would make Mr. Hoover say, I have to be there, sitting there, watching a man who's got all this experience. And by the way, that's the only reason I hired this man, was because he was experienced, that I have to be there watching him. The evidence will show in this case, ladies and gentlemen, that it was the plaintiff himself who chose to use an A-frame ladder. The evidence will show that he himself owns an extension ladder, probably more than one, that he could have brought and used an extension ladder. I heard this other lawyer get up here and talk to you about maybe bringing a scaffold. There was no talk of a scaffold. There's no need for a scaffold at this site. An extension ladder is perfectly appropriate for a job like this. And I mentioned to you a few moments ago, but I want to focus on it. Before this job, the plaintiff was here. He met my client here so that he could estimate the job. He walked around the building. He went on the inside, he was on the outside. He knew that you had the slab of concrete abutted by the grass. He knew all about that, but he chose to use the A-frame ladder, and he chose to set the 2 back feet of that ladder in the grass. You'll hear the cross-examination of him, and I ask you to pay very careful attention to that. He will admit to you that not only did he make, that solely did he make the decision to use the A-frame ladder, he'll admit to you that he has set up hundreds, if not thousands, of ladders. He'll admit to you, ladies and gentlemen, that with this type of setup on the grass, you would expect that the ladder could possibly shift or lean. Now, he's also going to tell you, consistent with the facts of this case, under cross-examination, you bet he's going to tell you that at some point during his job, he actually climbed down the ladder and had to move the ladder so that he could continue working. Well, ladies and gentlemen, what do you think his feet felt when he climbed down the ladder and got onto the grass? Do you think he felt the mud with his feet? Do you think that his feet sunk in? Do you think with his eyes he should have seen that the grass was wet? What does he do? He moves the ladder down 5 or 10 feet and puts it back onto the grass. That was his decision, nobody else's decision. If he wanted another ladder, he could have gotten one himself. He could have called my client, but it was his sole decision to use that ladder and to put those legs on the grass. But instead, what does he do? He wants to blame everyone else but himself for this accident. Despite the fact that he made each and every one of these decisions, despite the fact that he used the A-frame and not an extension ladder, despite the fact that he didn't cover the grass with a piece of plywood, despite the fact that he didn't use a scaffold, despite the fact that he knew he was using water that would create mud, all decisions that he made solely and on his own, he wants to blame someone else. Now, you may ask yourself, why would somebody with his experience go up a ladder, knowing it's wet underneath it, move the ladder, continuing to know that it's wet underneath it? And you will hear testimony from the witness, Diller. And Diller, ladies and gentlemen, was the security guard in the building. And he's going to tell you that when he got to that job site to take his post as the security guard for that evening, the plaintiff offered him a beer. That he saw a cooler of beers, and that in his lay opinion, the plaintiff was intoxicated and should not have been working. Now, I heard my adversary talk about Mr. Diller a few moments ago, but let me say this to you, ladies and gentlemen. Mr. Diller, he has no dog in this fight. He has no axe to grind. He has no reason to say these things, other than he was asked by the police, he was asked afterwards about what occurred, and this has been what he has told everyone who's ever listened to him right from the beginning. But ladies and gentlemen, even without Diller, and even without intoxication, the evidence will be so clear that each and every one of the decisions which led to this accident were made solely and only by the plaintiff himself. And with regard to the damages in this case, ladies and gentlemen, there's no doubt he had ankle fractures. There's no doubt that he had those ankle fractures operated on. There's no doubt about the fact that you'll see x-rays with some pins and some screws. You know what else there's no doubt about? There's no doubt that this is a man who voluntarily stopped going to physical therapy. There's no doubt that the evidence will show you in this case that this is also a man who has never sought out any vocational training, that there are places that are set up for this exact type of vocational training, and that he never took advantage of any of those things. But once again, that's not his fault. That's somebody else's fault, because that's the way that he lives his life. He presents himself as somebody who refuses to take responsibility, but blames others. And my clients, ladies and gentlemen, we will not accept that responsibility. And that is why we are here. Our trust in this justice system and in each and every one of you. And at the end of the case, I will have another opportunity to get up here and to address you. And that time, consistent with your oaths as jurors and the promises that each and every one of you made to me in jury selection, that if you found that he was the sole proximate cause of his accident, you would tell him so, and you would say, we're sorry, but it's time to start taking responsibility for your own actions. Thank you very much. Okay.